The land on which Massey College is located has for thousands of years been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. The meeting place of Toronto is still the home of many Indigenous people from across Turtle Island, and we are grateful for the opportunity to study, to learn, and to work on this land. My name is Mary Eberts, and I will be chairing today's panel, and I am delighted to have with me as fellow panelists Jeannette Lavell and Dawn Lavell-Harvard. I will introduce them at greater length. Let me just say that I met them through the legal work I have done on legislative committees and in many cases challenging discrimination under the Indian Act, both for individuals and First Nations and for organizations like Indian Rights for Indian Women and the Native Women's Association of Canada. The struggle has been going on for a long time, for the discrimination in the Act has been with us for at least 150 years. And the length of the struggle is demonstrated not just by the agonizing duration of time of some of the legal proceedings taken against the Indian Act sex discrimination, but also by the fact that the struggle is quite evidently multi-generational. Our panelists today exemplify the multi-generational nature of the resistance to that sex discrimination. Dawn Lavell-Harvard is the daughter of Jeannette Lavell, and both have served as presidents of the Native Women's Association of Canada and of the Ontario Native Women's Association, in addition to all the other wonderful things they have done. And more about that shortly. In the meantime, let me just try to hurry through the background of 150 years of discrimination against women in the Indian Act. I start with the jurisdiction given to the Government of Canada by Section 91 of the Constitution Act in 1867 over Indians and lands reserved for Indians. The Act did not define Indians, but very soon after Confederation, Canada introduced the rule that has been the subject of 150 years of litigation and law reform efforts. The 1869 Act for the Gradual Enfranchisement of Indians introduced the proviso that any Indian woman marrying any other than an Indian shall cease to be an Indian within the meaning of this Act, nor shall the children of such marriage be considered as Indians within the meaning of this Act. It also provided that women marrying men of another Indian band would become members of the husband's band, as would their children. The provision effected what Justice Laskin in the Lavell case called the statutory excommunication of Indian women. And why did the government put in these provisions? Many motives were claimed and have been claimed over the years, but the real reason for this restriction was that it was a very effective way of forcing the assimilation of Indians so that their lands would become generally available for purposes of settlement and economic development. Forcing generations of women and their children to assimilate in this way would reduce the Indian population, and the features of the legislation had the added benefit of making Indian families the very model of the Victorian male-dominated families that the colonial officials provided over. As Duncan Campbell Scott, Deputy Minister for Indian Affairs from 1913 to 1932 said, "This definition has greatly simplified the Indian problem." The basic design of the status provisions was maintained in the Indian Act of 1927 and the Indian Act of 1951. A person derived Indian status from being the child of or marrying an Indian male. Sections 11 and 12 of the 1951 Act set out those rules, and these are the ones that very often appear in the case law. Section 11 also provided that a child born to an unmarried status woman would receive status from her if that status was not challenged by the woman's band. This was the only situation in which status could be acquired from the mother. In 1951, the job of registering people as Indians was shifted away from the local officials and centralized in an Indian registry in Ottawa. Also in that year, the government added the double mother rule. Men could confer Indian status on their non-Indian wives, but if that happened for 2 generations, consequences would befall the latest generation. That child was only allowed to keep Indian status until he or she reached 21. The report of the Royal Commission on the Status of Women recommended in 1970 that this sex discrimination be removed from Section 12 of the Indian Act. By this time, Mary Tuax Early from Quebec and Jenny Margetts from Alberta had started the group Indian Rights for Indian Women, and the founding of the Native Women's Association of Canada would soon follow. Advocacy by Indigenous peoples across the board was growing. It was into this milieu that their case for women's rights would be brought to the Supreme Court by Jeannette Lavell and Yvonne Bedard, relying on the equality before the law guarantees of the Canadian Bill of Rights passed in 1960. The Supreme Court ultimately denied Ms. Lavell and Ms. Bedard their equality rights. However, Sandra Lovelace, a Maliseet woman from New Brunswick, went to the UN Human Rights Committee to pursue Ms. Lavell's quest for equality, and that committee ruled in 1981 that Section 12 violates the rights of association under the Human Rights Convention. Its equality guarantees had not come into force in time to effect Ms. Lovelace's claim. One other case decided before 1985 was Martin v. Chapman, and in the Supreme Court, and in that year, in 1983, the Supreme Court decided that a man could confer status on his male child born outside of marriage, but not on his female child. When Canada passed the Canadian Human Rights Code in 1978, it inserted Section 67 to protect the sex discrimination in the Indian Act from being attacked under that legislation. That section was in force for almost 30 years. 2 developments finally precipitated passage of reform legislation in 1985. One was the coming into effect of the Charter's guarantees of sex equality in Section 15. The other was the pending application to Canada of the provisions of the Convention on the Elimination of All Discrimination Against Women. This reform legislation, colloquially called Bill C-31, did a number of things. It enacted Section 6(1)A of the Indian Act, which preserved all of the privileges of men and their wives and their children which had characterized the former act. It enacted 6(1)F, providing that henceforth a person would have status only if both of his or her parents had status. This instead of making either the mother or the father capable of conferring status. C-31 also enacted Section 6(1)C, which restored status to women who had previously been deprived of it upon their marriage to a non-status man. However, the Act required that the status of those women's children would be determined on the basis of 6(1)F. That is, they had to have 2 status parents, and of course they couldn't. That was the whole point. They could not meet that test, and so they were given a new, lesser kind of status enacted by Section 6(2) of the bill. A person with this lesser status could not confer status on a child, and so the line of status holders would end there. The only exception was that it was if that person parented the child with another status person, thereby meeting the commands of Section 6(1)F. And under that 2-parent rule, there immediately arose the problem of unstated or ascertained paternity. A woman with 6(1) status could give her child some status under 6(2) if the father was unknown, but a woman with Section 6(2) status could not. Dr. Lynn Gale would subsequently have an Ontario Court of Appeal decision which addressed that serious anomaly. Since the passage of C-31 in 1985, there have been several important cases uncovering inequalities in this purported reform legislation. Sharon Machiver and her son Jacob Grismer went to the Supreme Court of BC with a challenge in 1994. In 2007, the Supreme Court of British Columbia agreed with their argument that C31 discriminated against those descended through the matrilineal line because of the combined effect of 61A and 61C. In 2009, the BC Court of Appeal narrowed that ruling almost to nothing by finding that the only discrimination was that 61A had given additional benefits to the children of double mothers, who could now keep their status for life, in contrast to the situation of Jacob Grismer. In 2009, the Supreme Court of Canada refused to hear the appeal from this decision, and so in November 2010, Machiver and Grismer filed a communication with the United Nations Human Rights Committee, and it finally ruled in January 2019 that the Government of Canada had violated the International Covenant on Civil and Political Rights. Their decision obligates Canada to ensure that Section 61A is interpreted to allow registration by all persons, including those in the situation of Machiver and Grismer, and to take steps to address residual discrimination within First Nations communities arising from the discrimination based on sex found in the Indian Act. Following the decision of the Court of Appeal in Machiver, the Government of Canada passed Bill C3. It was narrowly conceived to deal with the situation as described by the Court of Appeal. In effect, it allowed one more generation of full status before descendants of a woman restored under 61C would receive the lower version of 6.2 status. That means that the grandchildren of such a woman, rather than her children, will receive the lesser status. In 2017, Lynn Gale received a ruling from the Ontario Court of Appeal in her decades-long battle to be registered under 6.1 of the Act instead of 6.2. Canada argued that she could not be registered under 6.1 because her grandfather was unknown, and without knowing his identity, it could not be determined whether he was a status Indian or not. Without such a determination, her mother would only have 6.1C status, and Lynn herself would merit only 6.2 status. This in spite of the fact that Dr. Gale could trace her Indigenous heritage back at least 5 generations, as could Sharon Machiver and her son. Yet the technicalities of the Indian Act stood in the way of their proper registration. The Court of Appeal ruled in Dr. Gale's case that it was not necessary for her to know her grandfather's exact identity in order to establish that he had status. It reasoned that proof of the identity of a father is, as a matter of biology and common experience, more difficult than establishing their identity, the identity of a mother. There can hardly ever be any doubt about maternity. It recognized that a woman might have good reasons not to disclose the identity of the father, as in rape or incest, or may not be able to say for certain who he is, as in cases of rape. Dr. Gale had presented reasonable evidence that her grandfather had been accepted as a status person by the First Nation her grandmother belonged to, and the court held that this should be sufficient to meet the test, and that identity was not required. This interpretation of the government's unknown or unstated paternity rule was carried forward into the provisions of Bill S3. We're almost at the end of this saga now. In Deschanel and Yantha versus AG Canada in 2015, the Quebec Superior Court, Justice Mass, had to deal with a case which was, again, based on failures of previous law reform efforts. Stéphane Deschanel was not able to take advantage of the provisions of C3, and as a person with 6.2 status, he could not pass his status on to his children. Susan Yantha was the daughter of a male status Indian, but he could not pass his status to her under the Act because he had not been married to her mother. That problem in Martin v. Chapman emerged years later, never having been repaired by C31. After a minute examination of the Act and previous case law, Justice Mass ruled in favor of both applicants. She expressed her disapproval of Canada's reliance on piecemeal legislative reform as its only approach to removal of the discrimination in the Indian Act. And she said, in fact, that the Parliament was abandoning its duty by approaching this matter on a piecemeal fashion. She said, Parliament should not interpret this judgment as narrowly as it did the BC Court of Appeals judgment in Machiver. If it wishes to play its role fully, instead of leaving the field open to litigation, it must act differently this time, while also quickly taking corrective action broad enough to remedy the discrimination identified in this case. One approach does not exclude the other. Bill S3 was the result of Parliament somewhat reluctantly or somewhat confusedly accepting Judge Mass's instructions. I say reluctantly because the Government of Canada, appearing in the House of Commons, in which it had a majority, was only prepared to put a very narrow corrective bill forward as a response to Deschanel. However, in the Senate, a number of senators led the charge for a broader bill, and they worked very hard over a number of months to secure success for that bill, which was S3, working in conjunction with a number of individuals and groups in the broader community. And that brings us up to date, I think, with what has been happening with the legislation and the litigation. Let me now, before calling upon Jeannette and Dawn, give you a broader introduction to them. Jeannette Corbiere Lavell, a member of the Order of Canada, is an educator and lifelong advocate for Indigenous women's rights. She was born into the Wikwemikong First Nation on Manitoulin Island and completed business college in North Bay before moving to Toronto, where she worked for the Native Canadian Centre. In 1970, she lost her status under the Indian Act when she married a non-Indigenous man, and she challenged that provision of the Indian Act. Although her initial challenge failed, it inspired further challenges which ultimately succeeded. Ms. Corbiere Lavell has worked closely with many Indigenous organizations. She is a founding member and former president of the Native Women's Association of Canada and a co-founder and former president of the Ontario Native Women's Association, a non-profit organization established to support and empower Indigenous women. She attended and graduated from Teachers College at the University of Western Ontario and became a school principal and teacher. She has also performed government work. She served on Ontario's Commission on the Native Justice System and as a community consultant for the Government of Ontario. Dr. Dawn Lavell-Harvard is a proud member of the Wikwemikong First Nation and the first Aboriginal Trudeau Scholar. She has worked to advance the rights of Aboriginal women as the president of the Ontario Native Women's Association since she was first elected in 2003. She is the director for First Peoples House of Learning at Trent University, a position she's held since 2016. At that time, she left her previous role as president of the Native Women's Association of Canada in order to return to her roots as an educator. Dawn is a full-time mother of 3 girls, following in the footsteps of her mother, Jeannette Corbiere Lavell, a noted advocate for Indigenous women's rights. She has been working toward the empowerment of Aboriginal women and their families ever since joining the board of the Ontario Native Women's Association as a youth director back in 1994. She is co-editor of the original volume on Indigenous mothering called Until Our Hearts Are on the Ground, Aboriginal Mothering, Oppression, Resistance, and Rebirth, and has released a book along with Kim Anderson called Mothers of the Nations. Recently, she co-edited a book with Jennifer Brandt entitled Forever Loved, exposing the hidden crisis of missing and murdered Indigenous women and girls in Canada. The 2 women on today's panel could not be better qualified to give you more and more detailed information about the long struggle for sex equality under the Indian Act than these 2. And Jeannette, let me call on you first. If you have any stories from the time you brought your own case or work that you have done for the Chiefs of Ontario on citizenship codes, we'd love to hear about them.
How? Miigwech. I would like to introduce myself in my language first, in recognition of our teachings. How? Kiwed nang dishnikas, we kwem kong don jaba, and schnabe kwendau. Kadan mikon minim kindago a ajik mampi, mino ebsen the moat manda, no good to bachumang. I'm bringing greetings from my people, the Anishinaabe people who live on Manitoulin Island, which is land of the island of the Great Spirit. And just to say miigwech to all of you for taking the time to listen to us today. And also, Mary, that was really good to go back over the history, because it just makes me think today that after all what has taken place, getting to the place where we are today has been a real challenge, but it's also a sense of accomplishment and achievement for our people, our Indigenous women and girls. And that makes me feel much better when I realize that the positive aspect of this challenge. Because, you know, as you said, all this for me started 50 years ago. I just can't believe it. 50 years have gone by. And at that time in 1970, I had been working in Toronto. I met David there. We got married. That was April 11, 1970. And within a few weeks, I received this letter from the Department of Indian Affairs, that was, as it was called, which said, Jeannette Corbiere, you are no longer a member of the Wikwemikong Unceded Reserve. Enclosed, please find a check for $35. And that was it. It was startling, but at the same time, I did know that this was happening because I knew friends and relatives who had also lost their status. And in fact, the chief on my reserve at the time, his daughter lost her status when she married a man who he wasn't recognized as having status, so he was non-status Indian man. So all these consequences were there, but when you're young and you believe in justice and believe in the Canadian system, and I had been in Toronto working with Anishinaabe Institute, and we looked at the Human Rights Code and the laws of Canada. And I really thought that this shouldn't be allowed to happen. And we had met Clayton Ruby, who was also just speaking out on behalf of the rights of young people in the city of Toronto. And he had this book out called Law, Law, Law. And I had that book, and he was speaking to the young people at the Indian Friendship Center. And we talked about what our rights were as young people in the city. And when I got that letter, David and I said, we have to do something. So we went and met with Clayton. It was on a Thursday evening. And he looked at it, and first of all, he was flabbergasted that this was happening within a Canadian legislation. And then he further sort of startled us by saying, if you want to do something, you have to do it tomorrow. That was the last day. So he did. And that started us on this challenge that ended up in the Supreme Court, but so many ups and downs along the way. And it's when I realized this was 50 years ago, I did not, in my wildest dreams, ever thought that it would go through so many battles, hurdles, barriers. You know, it was just overwhelming at times, but I'm getting ahead of myself. But what I want to say is that thinking about it now, I think this was all meant to be, because in our teachings, we're boarding to our clans. In each of our clans, we have special roles and special duties and responsibilities to our community. My clan, which is the Bird Clan, it's Blackbird Clan, and we have responsibility to our people, which is to look at justice and make things, change things around. So I believe this was intended for me right from the beginning. And at that time, when we went to the first county court, it was in downtown Toronto, I really felt confident that this was obvious, it was discriminatory. Why should women be treated differently than men? Why should we be ostracized from our community? That's the only place I ever knew, grew up there, went to school there. That's where I belong. That's my people. And all of a sudden, to get this piece of paper that said I was no longer a member of my community, and in fact, I would have been charged with trespassing if I attempted to go and build a house in my community or want to take up residence or apply for anything. So that was, it was unacceptable. And at the county court, Judge Grossberg didn't see it that way. And what the perception in society at the time was, well, Indian women are sort of on the periphery and just didn't have a good reputation, I guess. And he looked at me. One of the first things he said was, well, why are you protesting this? You should be glad. He said, you should be glad a white man married you. And then he said, you know what the reputation of Indian women has been in our history. You know, but why would you want to retain that? And I was devastated. But Clayton, fortunately, said, don't worry, this is just the first step. So it continued to the Federal Court of Appeal, 3 judges, and they had a good look at it. And thankfully, they said, obviously, it's discriminatory, it's only affecting Indigenous women, Indian women, the term at the time, and should be thrown out. So I was happy, and we got challenged then. And I tried speaking, this would have been 1971 when I was first taking this to the courts. I spoke to the chief of my community, and he said, well, we can't do anything officially because we're working on it through the Indian Act within the civil service. I spoke to the Union of Ontario Indians, and they just said, no, this is our tradition. You have to leave it. This is not who we are. So we couldn't get any support from them. And one of our women in Thunder Bay heard, because all the media was there, and so we decided, they came in contact, and we got together in 1971, and we formed the Ontario Native Women's Association, because none of our leadership, who were mostly men, our chiefs in Indian organizations, would not listen to us. They would not give us any time to voice what was happening to us. So we ended up forming our own organizations with no funds. We did our own fundraising, bake sales, and just volunteered our time. And so we formed the Ontario Native Women's Association in 1971, and I had to be the president because it was my push that we need to change this. And then 1972, initially the Native Women's Association would not support us either. And I don't think they did so until 1973. 1973, 72, 73, those years we had so many oppositions from our own organizations right across Canada. But we as women, and as Mary talked about, we had Indian Rights for Indian Women, and right across Canada we formed our own Indian women's organizations and went to the Supreme Court on that basis. The Attorney General of Canada was the opposition, so to speak. They were all on one side of the Supreme Court. And us, Clayton Ruby, and the lawyer representing Yvonne Bedard, and us, we were there, but we had the support of the Ontario Native Women's Association, and actually by then, the Native Women's Association of Canada did come and support us. They didn't show up at that point, but I think on paper or in their motions, it did come about. So in 1973, we lost by one vote, and it was devastating to many of our women, and especially to women like Mary Tuax early. And Mary had been working on this issue for many, many years, prior to me even taking this to Clayton and to try and challenge it to the courts. And she used to say that all I want to do, and she was getting elderly, is be able to return to my people, be able to be buried with my ancestors. And she says that was her prayer every day. And when we lost in 1973 at Supreme Court of Canada, it was devastating to many of us. But our women are resilient, stubborn, kept on going, kept on talking. And as was pointed out, we did all the follow-up background work, committee work, and our women went to the United Nations and did all the challenges. And finally, in 1985, after all our work and determination and doing whatever we could to bring this to the forefront, we were able to get that one challenge through the equality section of the new Constitution. And thank goodness that it happened in 1985, because Mary Tuax early was one of the first women to get her status back. And she was able to return to her people, back to the place where she belonged. And so this was in 1985. But as was pointed out, we still had secondary status, and the legislation would not deal with what they're professing at the world stage, which was that there's no discrimination, we have a human rights code, everything's fine, our laws are all fine. And many more challenges had to take place. And many of our women were suffering through all this because those who lost their status, then the children, the implications of this denial of status to our women all those years had profound impact. And I believe we'll be talking about that later, but just to say that the attitude among our people through the media, because all this was a big focal point with First Nations and with media. And the Union of Ontario Indians, who initially had opposed this section, excuse me, I must be talking too much, but they asked me to be the Commissioner on Citizenship. And I accepted because I knew this was so important, and if I could do something within this capacity, and worked on this for several years. We spoke to our women, spoke to our communities, but the attitude, the feeling at the community level, at the reserve level, was starting to change because the loss of rights of our women and children and our grandchildren was impacting many of our communities. And the result of our community consultations was that the Anishinaabe Nation said, if you can trace your ancestry back through either your mother or your father and trace it back to members of your community, then you had that right to belong. You were a member of the Anishinaabe Nation. And in our language, we would say, "K'tebendagos, k'tebendagzeme," we belong. So our legislation within the Union of Ontario Indians, the Anishinaabe Nation, our citizenship code is called Edbendagzijik. So we are returning to that original place within our communities where we did our own governance. And that was one of the first things that we were able to do, along with recognizing our teachings for clans and responsibilities. And bringing us up to today, there's so many other things that need to be rectified, but I will leave it at that and just say, that's my story, and it took 50 years to reach this point where I now have, I can say I have my full status back, and my children, their status has been upgraded just through the latest bill. But everything is still not up to par. There's still more work to be done. So, miigwech for listening to me. Mary, thank you.
Thank you very much, Jeannette. It is a story that touches the heart and worries the conscience to hear how long you have had to struggle and your people have had to struggle for equal treatment on the basis of gender. Dawn, 150 years and counting. What remains to be done, and what are people doing about it?
Mm-hmm. So I think one of the things we need to recognize is, what is the legacy of this? Very often when people are talking about the status issue, it's often thrown out there that, we really should just get rid of the Indian Act. This is the fundamental problem. Get rid of the Indian Act instead of, continuing to amend it to return these women and their children. And the government has estimates anywhere from 80,000 to potentially 2 million. Personally, that wide a range of numbers shows that their estimates are essentially meaningless. But if we get back to this notion that there's this many people who have been excluded by the sex discrimination in the Indian Act, if we are going to throw out the Indian Act and in an attempt to replace it with something that would be less oppressive, discriminatory, objectionable, the challenge is that those we would be engaging with, those the government would be engaging with, would not really be the true pool of Indigenous people that should be part of that conversation, because there would be an entire swath of the matrilineal line that would be excluded from that conversation. The women and their children and grandchildren who had been excluded because of this historic sex discrimination wouldn't be entitled to be part of the conversation about what replaces the Indian Act. So that's why it's fundamentally important that we addressed that sex discrimination first in order to, as Jeannette mentioned, return all of those who belong in our communities so that they are part of that conversation moving forward. And this really is about eliminating our peoples. You know, if before this, the S3 went through, and in fact, we're still seeing it in many communities, that because of this multi-generational impact of our women and their children and grandchildren losing their status, we have hit the point in many First Nations now where we see parents or grandparents passing on, and they have no status descendants in order to inherit the land, to inherit the home. And so that property is returning to the government. And, you know, driving through Alderville just down the road here a little while ago, seeing a sign posted on the front of somebody's house that, you know, this property is available, contact the government of Canada, because it had returned to the government of Canada because that family didn't have anyone to pass it on. So this is creating a real crisis in many communities if, you know, our chiefs and our leadership don't acknowledge what's happening here. Is this was really about eliminating us as a peoples. And the focus on this distraction of, you know, that Carolyn Bennett kind of engaged in, these potentially millions of Indigenous women, children, and grandchildren who are going to be returning and overwhelming already overwhelmed communities, created a lot of division within many First Nations, and, you know, just repeated the cycle that happened with C-31, where people were concerned that there's already extremely long lines for housing. There's already extremely long wait lists for services on the First Nations. And this fear that all of this influx of Indigenous women, children, and grandchildren was going to be creating even less to go around is really shows a lack of understanding of the government's fiduciary responsibility to provide for the First Nations those basic services based on the number of citizens we have. So it doesn't necessarily mean that returning of our peoples is going to create less for those who are in the community. It could, in fact, potentially create a larger pool of funds in order to be able to service that community because your membership base is much larger. But this is the kind of propaganda, this is the kind of fear-mongering that is going on and is dividing our communities to the point where we see, you know, all of these various categories of so-called Indians with various statuses and lesser status. You know, I still remember growing up and, you know, being called, oh, you're just C-31 Indians. Like it's some sort of derogatory term that you're less than the real Indians. And, you know, because of what had happened with my mother. So understanding that this legacy really is about eliminating us as a peoples, and knowing that, you know, the Sawridge Indian Band out west, which was one of the communities that, in fact, fought in the courts for a very, very long time. In fact, until quite recently. I'm not sure if they've finally dropped. And if they have, it would be just in the last few years. They fought against the direction so that they wouldn't have to accept the women and children to be returned to their community. And that community, as I understand, is now down to their last status Indian child prior to S3 because of this discrimination. And so when you have a community, you have land, you have treaty rights, you have rights. I mean, we're all talking about our rights under the Indian Act, but if you don't have any status Indians to exercise those rights, then they become completely meaningless because you don't have a community anymore. That land reverts to the government, and that's what they've been wanting all along, is just to eliminate us as a people, eliminate that responsibility, and gain total access and control to all of our lands. You know, those final less than 1% that we still control across this country, you know, gain access to that last little bit. And so we can see now that even though we do have the legislation has gone through, we do have the legal right to be reinstated to our communities, it's the substantive right to exercise that is the problem. Because we have seen, as our women and children and grandchildren go to apply for their status, wait times of up to 2 years. Seen cases where a mother applies for her child with the under 16 form, and because the wait, even just to get a response, not to actually process the application, but to get a call back from the central registry in Winnipeg can be upwards of 2 years, means that, you know, when they did respond, they said, well, that child is now almost 18, you need to do a different form because they're not 16 anymore, under 16, even though the child was under 16 at the time when the mom applied. But, you know, we have seen cases where, you know, two siblings in the same family have applied with the exact same information. One gets their status back, one is denied. Cases where we have, one was even a set of twins. and one got their status back and the other was denied. So this kind of fundamental absurdity in the reinstating of our people shows a real lack of political will to actually enact this legislation after it was finally pushed by the Senate to get this so that we had the 6-1A all the way, so that there was truly finally removing that legislative discrimination. But what we're dealing with now is the legacy of that long-term exclusion, which means that our grandmothers, our mothers, and the children and grandchildren are also being excluded from the conversations, those decision-making bodies, those decision-making tables that are impacting the lives of our communities. We see there's a reason it was called the National Indian Brotherhood, and there was a reason we created our own Indigenous women's organizations, because they weren't addressing the needs of our women and children. And so, even this, the arguments for, they just don't have the capacity. We, in fact, recently were having a conversation with Minister Miller about what is essentially a new form of discrimination, that if any other Canadian citizen can walk into, or, now I'm sure because of COVID, it's all online, and unfortunately COVID has absolutely increased wait times for our women and children to be reinstated, that if someone can go and apply for a birth certificate and get an emergency birth certificate, a couple days, maybe 48 hours, you can do this. I've had to do it. You can apply, if you, previous to COVID, if you bought a plane ticket to Disney World and you can prove you have your plane ticket, you can get an emergency passport processed in a couple of days, 24 hours for real emergency. But, easily 10 days, 2 weeks is supposed to be the sort of expected regular processing time. But our people have to wait 2 years just to get a first response on their processing of their status. It's absurd. If we can't, we should have the right to expect the same level of service of any other citizen in Canada in order to access and process secure documents of these kinds. And this is clearly just another example of discrimination because we're only Indians that it's allowed to happen. So, these are the situations that we are looking at now. And unfortunately, we have seen cases where, this divide and conquer, the propaganda, the fear mongering that comes when you're in a community that has for generations, we'll be honest, has not had enough. They have not had enough food. They have not had enough for housing. They have not had enough to go around in the community for generations. So when they see a potential influx of new community members, they feel fear. They feel fear that there's going to be even less to go around. And this is creating a lot of animosity towards those people who, for no fault of their own, have not been allowed to be members and are simply trying to return to their community and, are being met with disdain, are being met with fear, are being met with resistance by those who say things like, well, they're only coming back now because they want, if there was, Curve Lake, there's settlements recently, treaty monies people are getting. And because that happened to coincide with the Bill S3, because that happened to coincide, there's a sense that people are just coming back to take advantage. And that's the result of this, historic divide and conquer process that's been going on in our communities. And that we really, and hopefully Jeanette's role as the Citizenship Commissioner has been able to help us see the impact of that on our people and our communities and as a peoples in future. So I'm not sure if there was any questions about, we're certainly pushing forward, not to tell the government how much money they need to invest in terms of processing the applications of our women and children and grandchildren, that maternal line, because really that's up to them. We're positioning it in such a way to say that our people deserve the same expectations, to be able to expect the same level of service of any other government documentation processing. And it's up to the government that they can then figure out how to process those, what kind of resources they need to put in place in order to be able to create that kind of genuine equality for our peoples. Thank you.
Let me just ask you a question based on some of the things that the Government of Canada and the courts have been saying. Back in the day when this provision was put in that the woman had to follow the man and would lose her status if she married a non-status man, one of the justifications for that was that this was the way the First Nations did it. This was their culture, this was their tradition. And then we see as recently as Justice Groberman in the Machiver case in the Court of Appeal saying, well, this provision is justified because it reflects the traditional culture of the Indigenous peoples. And then Dawn, to bring this forward to your mention of the current negotiations for modern treaties or for sectoral agreements, first of all, was it the case that the male-dominated culture was typical? And secondly, if it wasn't typical, if there were societies which had women leaders, how can they reflect their traditions in their modern agreements if the women can't get to the table because they're not status? Can either of you offer some comment on that?
So absolutely, it was not the case that this was our traditions. I mean, even the notion that this was our traditions as First Nations people, the distinct culture, language, and traditions that varied from the Beothuk on one coast all the way to Haida and Bella Bella, all the way to the Dene in the north, it's absurd to think that they can identify that there was any one cultural tradition that points to some sort of patriarchal history among all of our peoples. The diversity among those peoples is the same as the diversity from, you look at just even the landmass. That's like saying that, the Italians, French, English, Scottish, all the way to Norway, and it's absurd to think that you can say that we were all the same, because that was not the case. And even among the Anishinaabe, we had matrilocal, which means that the women and children stayed with the women's line in terms of their physical geography, and the man joined the woman's family and community. Matrilineal, which meant that the children, they traced their lineage through the mother, and the matriarchal. And I mean, everybody knows how among the Haudenosaunee, the clan grandmothers chose the leadership. So it's not necessarily even just about the gender of the chief and the leadership. It's about very many different processes in very many different communities that ensured there was equality for men and women within our nations. I think the notion of that equality is something that goes through most of our nations. And so it's an absolutely absurd argument to make. And it's an absurd argument to make in a modern society that says that, there are also cases of slavery being among some First Nations, among different places in the world. And nobody would dare to argue that because there was a historical tradition of slavery that, we can allow that kind of thing to continue. So that kind of stuff, it's actually mind-boggling when some of these arguments come up for me, because, culture is a guide. Our traditions evolve over time. And that's one of the challenges of people from other nations can point to, if somebody's living in Canada and their origins come from Scotland, they can point to contemporary Scottish homeland where people are living in a contemporary, modern 2020 with pandemic masks and locked in their house in Scotland right now. Nobody's expecting them to still be walking around in their Braveheart with a broadsword and kilts through downtown Glasgow. But yet, because this is our country, and because the sort of homeland that people would think for our peoples exists in time, not geography, people look to Indigenous peoples as our only culture that is, sort of allowed as being authentic or valid by the larger society, is what existed 500 years before contact. And it denies our people that ability for our cultures to evolve the same way cultures around the world evolve. And so this is one of those fundamental problems of how our peoples are being, encapsulated in a bubble and not allowed to have our cultures evolving the same way as other peoples, lest we be isolated or to be turning white because, we drive a pickup truck or have cell phones. There's this notion that we have to live in this sort of prehistoric, archaic way. I think I've already forgotten your second question.
Well, I'll change it then and ask you both this. The UN Declaration on the Rights of Indigenous Peoples is often cited as offering a great deal of support for what you are asking for, absence of discrimination in determining membership. And in the throne speech, Canada announced that it would put in legislation to incorporate that right into Canadian law, so that it wasn't just advisory anymore, it was part of Canadian law. Do you think, first of all, that this is a serious promise and will get done? And secondly, what do you think it will mean for the drive for a freedom from gender discrimination? Do you want to start?
Well, honestly, right now, yeah, I'm a little concerned. I'm really cautiously hopeful that we can have a genuine, meaningful conversation about exactly what you said, what that looks like. Because it's one thing to say that we're going to have, our people be allowed to speak for themselves. The challenge is that the only organizational, the only voices that the current government listens to in terms of their nation-to-nation, respect for Indigenous peoples are those organizations that were created by the Indian Act that excluded women. And so, there's a reason it was originally called the National Indian Brotherhood. Let's not pretend it is now called the AFN, but to suggest that the AFN, which is itself a legal corporation, it is an organization, the same as the Métis National Council, the same as the Congress of Aboriginal Peoples or the Native Women's Association of Canada. But to pick and choose which national organization gets deemed to be the voice it's creating a very big gap in terms of the rights of the female line of that matrilineal line, who, because of this historic sex discrimination, have not had the same opportunities to participate in that, chief and council leadership within our First Nations, because literally it's only been as recently as, last fall that we even have a right to be members of our bands, much less access that political process within our bands. It means our voices have been silenced. And the thing is, we were standing there in New York when Carolyn Bennett stood up and said that this government endorses and fully embraces, the United Nations Declaration on the Rights of Indigenous Peoples. And under Article 18 says very clearly, Indigenous peoples have the right to participate in decision-making in matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. And that right there, by only recognizing the AFN, the Canadian government is denying our rights under the United Nations Declaration of the Rights of Indigenous Peoples that they themselves have endorsed. I stood there with Carolyn Bennett when she said it. And so they're denying our fundamental rights under the United Nations Declaration by not recognizing the legitimacy of Indigenous women's organizations, which were created out of necessity because of that sex discrimination in the Indian Act that removed the voices of our mothers and grandmothers and our children and grandchildren from that decision-making process. And so if this is really going to be meaningful, they're going to have a look beyond the sort of big three national Indigenous organizations, or it's just going to be more of the same.
Okay, I think we're almost at the end here, and I want to give Jeannette the last word. You can either say anything that comes to mind, or here's a question for you. What would you like to see from the government and from allies in order to advance the claims to full gender equality on the part of Indigenous women?
Okay, miigwech. Thinking back over the years, not just the last 50, but 150 years, all the difficulties that our women, our children have been put through because of legislation that was imposed on us as Indigenous people in Canada, it's staggering to think of the consequences. And this law did not come from us as Indigenous people. And as Don pointed out, we have so many different tribes and customs and ways of working together within our communities. And that equality was always there within our teachings, that balance. So this whole concept of women not having any rights and not being listened to, not having voice is foreign to us. And it took us a long time to get our men to recognize that, to get them to realize that the premise of National Indian Brotherhood did not follow our traditions. All we have to do is look back at the treaties. When our original treaties were signed, the leadership were chosen by all the people, and that included the women, and the leadership spoke on behalf of all the people who were there with them, that they were designated to speak on behalf of. And it recognized all people, men, women, even some non-Indian people who were there. That was our tradition. And now we come down to this day and age where we look at those treaty rights, and the government backtracked, and they put in provisions within the Indian Act which removed many women. If an Indian woman who had status married an Indian man who had status but did not have those treaty rights, she also lost her treaty rights. That's not designated in the Indian Act, but it's been applied by the civil service. Consequently, we have many more people who are not recognized as being treaty. That's one of the discriminations that are still there. I myself lost land because of Section 12(1)B and lost access to programming. And I'm just one individual. Think of all the countless, the hundreds of other women who were not able to be part of their communities. It's so many hardships and sad stories. I would like to believe that now, in this day and age, after going through all this, that the current government, especially, I would like to believe that they would recognize, maybe do an apology that they did for other Canadian citizens who were mistreated, because obviously we were mistreated. And if there's some way reparation could be done, that would also take some of that hardship, that sting about what we have lost, that sense of belonging to our families. That's a real powerful feeling, and to have it taken away from you by legislation, by an outside government, it's really disheartening. So I guess before I join my ancestors in the spirit world and my other sisters who have been here with me for this challenge, I would like to believe that we can see all that discrimination removed from legislation, and that sense of reparation there. We can talk about it, but I would like to believe can be done. Miigwech.
Thank you very much, Jeannette, and thank you to both of you for a very insightful and moving account of 150 years of discrimination in the Indian Act and 150 years of determination to get rid of it. Thank you.